Good morning, everyone. Rather good afternoon, and welcome to the Samfiru Tumarkin Employment Law Question and Answers. My name is Lluc Cerda. I'm a Senior Managing Associate at our Calgary office here in Alberta. I'll be taking your questions today on anything related to employment law that you want to discuss. Feel free to put your questions in the chat. We'll be happy to talk. Before we get into it, I wanted to bring to everyone's attention a post on our website made by my colleague Haley Rushford discussing a recent Human Rights Tribunal case. It's recent, it's restating something that we all know, but sometimes might not be known by the general public. In this case, it was the situation of a gentleman who unfortunately suffered from alcoholism, and because of that was late to work and a no-show at work on several occasions before he was terminated. He disclosed in his termination meeting that he was struggling with alcoholism and was planning on attending Alcoholic Anonymous meetings. That didn't change the employer's mind about terminating him for cause. So fast forward a few years and we're at the tribunal, and of course the tribunal found, as they've been finding consistently over the last few years, that not only did the employer have a duty to accommodate this gentleman who was suffering from alcohol addiction, but they actually had a duty to inquire about the addiction. So a lot of times we'll hear from employers, well, how could I accommodate this person if I didn't even know they had a disability? And the fact is, oftentimes these employers do have some sense of the disability, be it alcoholism or another type of disability, but they choose not to ask questions to have that defense that they didn't know this person was disabled. In fact, the courts are pretty clear that once there is a factual basis for you to believe that someone's lack of performance is due to a disability, you have an obligation as an employer to inquire more deeply, to ask those questions to see if there is a link between the disability and the issues this person is having at work. So I know it's a subject that's hard to talk about for a lot of people that are suffering from addiction. Or any mental health issue, actually, one of the hardest things to do is to acknowledge that there's a problem. That said, you're not alone in the sense that that's part of the disability. That's part of the issue that you're having. You have a mental health issue. You might not even know you have one, or if you do, you might be so ashamed that you don't want to talk about it. But in actuality, the employer, if they're able to independently assess that there are some issues there, either with mental health, physical health, really, or addiction, then they have an obligation to look deeper, to look further into what the issue could be and how they can accommodate you so that you can keep your job. And if the employer fails, as they did in this case, fails to accommodate you, then they'll be on the hook for damages. All right. So this gentleman, on top of lost wages, was awarded $25,000 in human rights damages. This gentleman actually was only working there for 16 months. Nevertheless, received that compensation. So I have a first question coming in here from Keith Smith. Keith asks, what is an arbitration status conference, and can you still settle your case in arbitration? So Keith, I'm not exactly sure if you're referring to a unionized arbitration. So basically, there are two types of workers out there. Those that are unionized and those that aren't unionized. Here at Samfiru Tumarkin, we represent non-unionized workers. So non-unionized workers will usually go through the courts if they're looking to enforce their legal rights, their employment rights. Unionized workers go through an arbitration process. It's a mandatory arbitration that you go through as a unionized worker, and you cannot access the courts generally to have a judge determine what your employment rights are. So in the arbitration context, there are different rules and procedures, but I don't work with unionized employees, so I'm not exactly sure what the status conference will be dealing with. I suspect they'll be trying to make sure that everyone is ready to proceed with the arbitration hearing. But if you are represented by a union, Keith, I suggest that you speak to your union lawyer or to your union representative to get more details about the process. You always want to know what you're going into before you go into it. So definitely reach out to them, ask them what this is about, and see how they can help you out. JC 2004X asks, when an employer hires someone of a certain race, age, or immigration status in order to get a government grant or credit, is that then discrimination against other applicants, or is that allowed? That's a good question, JC 2004X. So there's something called, colloquially it's called positive discrimination, otherwise known as affirmative action. So essentially, affirmative action in the United States has troubled history, but it's well ingrained here in Canada, in the sense that courts will allow employers, universities, higher education to select from underrepresented groups in order to make sure they're no longer underrepresented in the future. So that's well established. That's allowed. At the same time, you have to look at the details of each policy. I can tell you from a more general standpoint, it's not illegal. How that policy is implemented may result in certain findings that it isn't really helping underrepresented people acquire more representation and is in fact discriminatory, but we'd have to look at the policy itself. But is it illegal to have a policy that promotes the full representation of underrepresented groups? No, it's not illegal, not here in Canada. Julie Acrius asks, is there a difference between an unpaid leave and a layoff? Can a permanent layoff be different than being fired? Great question, actually. Uh, so I've been dealing with this a little bit in a court of appeal decision that I just argued in Ontario. So in that case, essentially, my client had been laid off due to COVID-19 in March 2020, and then the government of Ontario basically ended up saying, well, all these layoffs due to COVID, they're no longer layoffs. So we're going to call those a leave of absence. All right. So that's kind of the cliff notes about what that is. And in essence, we had to, the other side argued that, this person's not on a layoff. This person's on a leave. So why are we talking about layoffs? In fact, the courts have already addressed this, including the Manitoba Court of Appeal. A leave and a layoff is the same thing. It's the same thing in terms of whether it amounts to a constructive dismissal. So when you're laid off for the first time, or if you're forced to take a leave of absence, your income has basically been reduced to zero and your hours have been reduced to zero. Generally, that is considered a constructive dismissal in the sense that the employer has not said, well, you're terminated. They haven't used those words, but in actuality, let's look at what's happening here. You don't have hours at work and you're not getting paid. So you can treat that as a constructive dismissal in the sense that you can quit that job and still be entitled to severance. All right. So whether the employer places you on a leave of absence or a layoff, if they unilaterally impose that and there isn't a past practice of that happening, then you can claim you've been constructively dismissed and go after your severance. Absolutely. So there might be good reasons why they would place you on leave. I mean, we'd have to look at each case individually. For instance, they might say that you're, I don't know, you I don't know, hurt your leg at work. It's clear that you need 2 weeks to recover, but you refuse to take them, but they think you might be a danger to yourself and others at work, so they're going to force you to take a medical leave. Maybe that's reasonable. Maybe we'd have to get the facts. On the other scale of the things is well, listen, business has been down 30%. We can't afford to employ you, but we're going to lay you off. We're not going to lay you off. We're going to place you on leave. Well, that's clearly the same as a layoff, really. And so you're entitled to go after your severance if you want to. Now, you make another great point that a layoff cannot be permanent. All right. There is this notion that people call permanent layoff. they think that's something. That's actually nothing. A permanent layoff is a termination. And just like any other termination, any other without cause termination, if you're permanently laid off, you'll never be recalled back to work. You're entitled to your severance. So there's no difference between being permanently laid off and terminated. In both cases, if it's on a without cause basis, then you're entitled to receive your severance. So we received a question here from Diane Robitaille. She's asking, I was just given a 5-day suspension for insubordination. This is my third suspension due to the fact that back on June 26, 2020, we were told that we would be working permanently from home, having only to come into the office once or twice a month as needed. In September of 2020, I sold my house in Toronto and moved 3 hours outside the city. In June of 2021, there was a notice that the office would be reopening for people to start coming back into the office 2 or 3 times a week. We were told by our boss that it did not apply to us as we were not needed in the office, and it was the manager's discretion if it was needed. In September of 2021, a notice came out that it was now mandatory to come into the office 2 to 3 times a week. I told them it was not possible for me to do that, drive 2 times a week. And now you were 3 hours away. And if I had known that, they would be changing their minds. I would not have sold my house. Friday at 10 a.m., I was told that I would be getting a 5-day suspension without pay starting May 2nd. I asked why it was not immediate, as that is how it is normally done. Got no real answer, but found out today the reason was because my boss was going out of town this week on business and they needed me to cover for him. How will this help in a court case if I take them to court? All other suspensions were immediate, if anything. I don't think the fact that they delayed the suspension really is going to be a very important factor if you do take this on to litigation. You do seem to have a case here where you basically might have been constructively dismissed. So what's important here to remember is that you really want to have something in black and white saying that the move to work from home is permanent. If the move to work from home is permanent, then you're entitled to rely on that and adjust your life accordingly, which means, as you did, moving away from your home. And so moving away from your office to about 3 hours away. So in that case, just as if they had moved their office 3 hours away, you can say, well, this has now become impossible for me to perform this job, essentially, because of the way you've shifted your policy over time. This had become a fundamental part of my employment, that I'd be working from home permanently. And now that you're changing that, you've changed a fundamental part of my job, entitling me to claim that I've been constructively dismissed. So if you do have that solid evidence that they told you, no, this is not temporary, this is not even for the medium or the long term, this is permanent, you'll be working from home, I think you do have a case that you can go after them for severance. So if that's what you're wanting to do. Unfortunately, there isn't really any other options that we can force them to do. You kind of have to decide whether you're willing to walk away from your job. There's no way that we can force them to allow you to work from home legally. That could come out, through negotiations, but you can't ask a judge to force them to employ you from home. The only thing a judge can award you is severance. So now you have to decide, am I willing to walk away from my job and go after severance? If you are, then I recommend that you contact us. JC2004X asks, does receiving severance affect EI eligibility? So the traditional rule was that you couldn't receive severance and EI for the same period of time. So imagine you get terminated on Jan 1, 2022, and you receive severance that's going to cover you until April 1, 2022, just to use that number. You would only be eligible to receive EI after April 1, 2022, after your severance period has run out. Okay. However, because of COVID, the government has changed that policy. So the policy now is that you can receive EI immediately following your termination, even if you're in receipt of severance. So you'll be able to get both severance and EI. That's been going on since September of 2020, September of 2020, and will end in September of 2022. Okay, so you actually, it's been going on since the start of the pandemic. They made the rule adjustment in September of 2020, but all the way up until September of 2022, if you're receiving severance during that time, you can also receive EI. Belinda Beguilin asks, I've read that it can be difficult to prove discrimination in the workplace. How can someone who is dealing with discrimination prove that it's going on? That is always the challenge. So basically, discrimination usually results, the successful cases usually results in a discriminatory act happening. So for instance, you're terminated because of your disability. So the discriminatory act is the termination, and that's easy to prove that you were terminated. And then it's proving that your disability had a role to play in that. So that could be, was the employer aware that you had a disability? Did they have a duty to inquire? When did they find out, and all of that? So if for instance you're struggling with a disability, I think it's important to let the employer know that you have this disability and that you need an accommodation. There are other protected grounds that don't require accommodations. So, if you're being discriminated on based on your race or your gender or your gender expression or things like that, you're just basically being asked to be treated like everybody else. You're not asking for a particular accommodation. And a lot of people sometimes feel that they're being passed over for promotions or things like that because of these protected grounds. And that is actually quite hard to prove sometimes. How do you prove that this other person got the job instead of you, and that the reason that happened is, for instance, based on your race or your gender or anything like that? It is tough to prove, not impossible, but you definitely, in a situation like that, you'd go through the process of having the employer justify why they hired this person rather than you. Uh, uh, and if they don't have a reasonable explanation, then it might be that you're able to prove that it was based, at least in part, on this protected ground that you're alleging was discriminated on. You were discriminated on. So, in terms of what can you do to kind of set up or prove, create a file for yourself where you claim discrimination. um, it's important to kind of realize what ground you're claiming. Sometimes I have some people come to me and they think they've been discriminated on 6 different grounds. Um, you it's not impossible, but at some point it should be one or two, maybe interrelated. It could be your ethnicity and your race. For instance, you're going to have some kind of trace somewhere, either in an email or a performance review or something like that, that certain comments were made about your race or your ethnicity or things of that nature. Now, another thing that I recommend people do is keep a diary, keep a log, where if something happens to you that day, go home and write it out in some sort of diary, with as much detail as possible in terms of who, where, what, when, and why. Who was there, what's their title, what time, who witnessed it, what was said. Uh, it's not as good as, for instance, having a video recording of the meeting. But you can imagine, like, this human rights case that I was talking to you about earlier in the show, that happened in 2016. This guy's testifying in 2021, 2022. Memory fades. So to have all of that with all the details, including dates and names and what was said verbatim, will be helpful down the line. So having things like that at your disposal is always helpful. So in the event that you're unable to obtain, incriminatory evidence through, emails or video recordings or audio recordings, at least do that. Another thing you can do is follow up. For instance, you go to a meeting, performance review, and you're told, for instance, that you're not available enough at work, and you tell your boss, well, listen, I have a 2-year-old at home I have to take care of, and your boss says they don't care, be at work, you're required to be at work. That could potentially be discrimination on the basis of family status. So doesn't hurt to follow up with an innocent email recapping the meeting where you said, listen, I told you I have a 2-year-old that I have to pick up from daycare at 5 p.m. That's why I'm leaving right at 5. You told me it doesn't matter. I have to figure out, how to put in more hours so I stay on top of my work. Even if they don't respond to you, the simple fact that they got this and then say, no, what you said is incorrect, helps establish that that's what happened. All right. So you can send them that email, just kind of recapping what was said and see if they respond. And that at very least might start a more fulsome conversation on how you can be accommodated regarding your family status. I got another question here from Diane Robitaille. I don't have it in writing. It was all verbal. I have been fighting with them since October. So Diane, you was the one telling us that she sold her house and moved away from her workplace based on the fact that she was told that she would be working from home permanently. So Diane, that can be a challenge, frankly, if you have nothing in writing, unless you can have colleagues confirm that that was said to all of you in some sort of team meeting or said to them as well. Generally, if this kind of situation arises for anyone, you want to get that in writing, confirm that that's actually, the new policy, that you'll be able to work from home permanently. So once again, for those of you who are just joining, my name is Lluc Cerda. I'm the senior managing associate of our Calgary office of Samfiru Tumarkin. I'm here to discuss your employment questions today. We have a lot of information on our website as well. That's employmentlawyers.ca. You can visit our website anytime to take a look at what resources we have available for you. If you want to contact us to schedule a consultation, feel free to take a look, employmentlawyers.ca. We have a question from Facebook here. Tasha asks, how frequently do you see employment disputes going all the way to court, and how long do cases typically take to settle? Sorry about that. All right, so I can tell you with confidence it's about 1% of cases, if not less, that make it all the way to a hearing. All right, 99% of cases settle prior to a trial. I think that a lot of my clients, when they first approach me, are very concerned that the next thing they do after they hire me is get ready for court. We see it on television, Law and Order. The crime happens in the first 10 minutes of the show, and the second 10 minutes they're in court. In reality, there might be as much as a 2 to 3 year span between those two segments. All right, so that's really one classic way in which television law does not match reality litigation. All right, so 99% of cases in civil cases settle prior to a trial. In terms of how long it takes to settle, there's basically 2 or 3 kind of stages in a litigation, or actually in the life of a file rather than before we start with litigation. So generally, at our firm, the practice is to reach out to the employer once we've been hired to see if we can come to a resolution prior to even starting a lawsuit. All right. And I can tell you in about 50% of our cases, we're successful in getting our matters settled, even without even having to proceed to litigation. And so if that happens, then you're looking at a timeline of about 1 to 3 months. The other half of cases, we have to proceed to litigation. And the logic behind proceeding to litigation is not that we've given up on settlement, that we don't think this case can settle. We're going to trial. We're going to have to fight this out. This allows us to use some of the tools in the litigation process to move the matter towards a resolution, be that settlement, be that a trial. Because the fact is there's no real kind of rules prior to litigation that allow us to force the employer to do certain things, to force the employer to address your concerns. So a lot of our cases will settle probably at the next step after we've started a lawsuit, which is mediation, where the parties meet with a neutral mediator to try to resolve their matters. And that's usually scheduled between 3 and 6 months after you start the lawsuit. So you have a vast majority of our cases that within 6 to 8 months are resolved. That's the, and most of those will be even prior to litigation. So that's kind of the life of the file, of most typical files here at the firm. Sam asks, what are the options to getting time off for a religious leave, i.e. a pilgrimage? And would it be paid or unpaid? So there's kind of two approaches you can take. One is to informally approach your employer and see if you can just get some time off, right? So you can either use vacation time, you can take some unpaid time off, some sort of sabbatical. Employers might be okay with that. If that's not an option and you need a religious time off, then there are certain considerations that come into play. So if you're trying to go to a pilgrimage, you're going to have to establish that there is a requirement for you to attend this pilgrimage. Now, I'm not by any means a religious expert, but I do believe, for instance, that people that practice the Muslim faith are asked to do the Mecca pilgrimage once in their lifetime, right? So again, the employer may have a duty to accommodate you there if you can show that you have to do it this year or at some point now. On the other hand, the employer may very well just tell you, well, you have the rest of your life to do this. You can save up vacation, you can, um, uh, or something like that. If the employer, though, if you're able to convince the employer that, you require an accommodation to attend this pilgrimage, then you can expect that it'll be unpaid unless you're using vacation time again. Yeah, because if you're not at work, there's no obligation to pay you. Deepak Dalawal asks, I got fired. I had an employment contract. It said that my severance pay is limited by the Employment Standards Act. Is my severance pay limited? So what we see a lot in employment contracts, especially more recent employment contracts, is they'll contain a clause called a termination clause. And the purpose of the clause is to limit your severance entitlements to what's contained in the clause. And what's contained in the clause is usually the minimum that you're owed under the Employment Standards Act in the province where you live. Now, for instance, in Alberta, you can be a 10-year employee or more. You can be a 30-year employee. In fact, the maximum the Employment Standards Code of Alberta provides is for 8 weeks of termination pay. You can imagine that your actual severance entitlements can be as much as 10 to 24 months in certain cases, right? So there's a big difference between 8 weeks and 24 months. So of course, employers put in these clauses so they don't have to pay you the 24 months of severance. Now, the problem is that these clauses are interpreted or read by the courts very restrictively. If you've heard of, getting away on a technicality, this is really it. The area of termination clause litigation and jurisprudence is filled with technicalities. It really is. So although a lot of employees have this clause in their contract, I think it's very important that you contact us, contact a lawyer to have us review these clauses. I can tell you in my experience, 80 to 90% of these clauses are not properly drafted, to the point that if they're not properly drafted, it's as if they didn't exist, and you can go after that 24 months of severance that you might otherwise be entitled to. So definitely a lot of money on the line here. It's worth reaching out and having us review that termination clause. Now, I told you can get up to 24 months of severance. How do you know how much you specifically are entitled to? Very easy. You can simply visit our website called Pocket Employment Lawyer. We have a severance pay calculator on our website. You just answer 4 easy questions, and it'll let you know how much severance you're likely entitled to. no obligation. Whether you've been terminated, you just want, you're just curious, you're asking for a friend, we're not going to ask you your name or anything like that. Visit pocketemploymentlawyers.ca and get an idea of what your severance entitlements might be. JC 2004X asks, while off work due to an injury and logging shifts for a settlement, what do you do if, as a gig worker, an employee stops sending work offers knowing that you can't accept them? JC 2004X, I'm not exactly sure I understand your question. So you're off which job? Your gig job or your regular job? And I'm not sure I follow the question. Um, Generally, if you've told your employer that you're not available to work, then your employer will not send you work, whether that's discriminatory, whether that's constructive dismissal. If you're telling your employer you need time off from work, then that wouldn't be any of that. You should be on a leave of absence. Generally, also, if you are on a leave of absence, it's not necessarily a great idea to go and pick up gig work. For instance, imagine you work in a factory, you press metal and you hurt yourself, and you tell your employer, and you tell WCB, I got to be off work to take care of my leg injury. And then you go off work for 6-7 months, whatever it is, but during that time you work for Uber, right? So you should be at home convalescing, and you're out there working. If WCB finds out, if your employer finds out, you're potentially risking your job and WCB. You might be forced to repay WCB, actually. So if you're off work for disability, it's not impossible that you can work another job, but it's got to be a job. You got to be a job that's different enough from the job you were doing that you can do that job and still be unable to do the other job. In any case, you should probably disclose that at least to the insurance or WCB, that listen, I can't stand, but I'm doing some data entry from home, for instance. That might be okay. But if you're in landscaping, you hurt yourself, you're at home convalescing, and you're doing side gigs for another landscaping team, that could be problematic. So you want to watch out there. JCX has followed up, actually, so I'm just going to actually, I'll answer Sean Tammy Cartledge's question. I have been placed on an unpaid leave of absence since January 2022 because of non-vaccination issue. I've just been offered to start negotiating a severance. Would I be able to negotiate that myself, or should I seek to gain legal representation? I've been corresponding myself at this point. So in reality, Sean Tammy, I think you are allowed to negotiate your own severance. There's nothing illegal about doing that. Will you get the best offer that the company is willing to make? I doubt it, personally. My experience has been, for better or worse, you're taken more seriously when you're represented by a lawyer. So firstly, you understand more what your entitlements are, and basically you have someone advocating on your behalf that knows how to get you what you're actually legally entitled to. So if you want to reach out and get an idea of what your entitlements might be, our website, once again, is employmentlawyers.ca. Reach out to us. We'll set up a time with you to discuss your severance entitlements. So as I was saying, JC 2004X has followed up. So I'll answer that question as our last question here. We're running out of time, unfortunately. So JC 2004X says, while off work due to an injury and logging shifts for a settlement, what do you do if as a gig worker, when an employer stops sending you work offers, knowing that you can't accept them? I work for multiple companies. I've been told to log missed shift that would have worked. The injury is not employment related. Now, I understand that the injury might not be employment related, JC 2004X, but if the injury is preventing you from working, the The simple answer to this JC 2004X is to go get a doctor's note, figure out with your doctor what you're able to do or not. If you're not able to accept shifts, then I don't see how it matters that they're not sending you shifts. If you are able to accept shifts, then yes, they have a duty to provide those shifts to you, absolutely. So first question would be maybe reach out to us. We can get more information on what your doctor says you are able and unable to do. But right now, if you're telling me, yeah, I'm unable to work, I have to somehow log shifts for some accounting purposes, but I actually can't accept any shifts or any gigs, then I don't see what the problem is really. But there might be more to your story. I think we're running out of time today to be able to answer that question. But it's an interesting case. I think if you are able to accept shifts, then they should provide you with those shifts if they know that you're able to accept shifts. So if you're able to work, then they have an obligation to provide you with work. All right. Well, thank you everyone for tuning in today. My name is Lluc Cerda. I'm a senior managing associate at our Calgary office of Samfiru Tumarkin LLP. I was answering your questions today about employment rights. We'll be continuing with shows on Wednesday, Thursday, and Friday. So if we didn't get your questions answered, then feel free to tune in. We got Lior Samfiru who will be taking your questions on Wednesday. So if you have any follow-up questions or any new questions that come up from here to then, feel free to reach out. Thank you all for joining us today, and I hope you have a great rest of your day.